edging towards evening. It gets very dark in winter in Johannesburg, where we are. And I am extremely delighted to introduce to you a very old friend of mine, Professor Tshepo Madlingozi. I was joking earlier on before we started that he's got his nickname is Links in our circles. So we have a very fascinating topic today, which is entitled "The Human Rights Commission's Role in Shaping Law Students and Social Justice." And no better person than Professor Madlingozi to take us through this narrative. And of course, at Regenesis Law School, it's exam time, but this has been opened up to lawyers and anyone else who's interested in the area of social justice. And of course, this is a constitutional discussion. We are following from the last LLB MasterClass, which we had with attorney and former Premier of Mpumalanga, Matthews Posa, former ANC Treasurer General. So, Professor Madlingozi, I just want to highlight that we've known each other for many, many years. You remember, Prof, that we met in Ghana for the first time when he was representing the University of Pretoria and I was representing the University of Natal in a moot competition, if I recall. I think my facts are correct. Am I getting it correct? Yeah. Yeah, and at that time he had more hair than he has now. He had dreadlocks and, but there are many fascinating things about Professor. He studied law and sociology in South Africa, Cameroon, and the United Kingdom. And then before being appointed to the commission, he was director of what is known as CALS, which is the Center for Applied Legal Studies at Wits University, where I also taught at some point. And he was also an associate professor at the same university. And of course, at the University of Pretoria, Tuks. He had a lengthy relationship with Tuks as well. And he's done consulting for the Pan-African Parliament, UN Office of Human Rights, among other very exciting endeavors. He sat on the boards of several civil society organizations, including the boards of Rural Democracy Trust, Socio-Economic Rights Institutes, also known as SERI, which does great work, the Journal of African Writing, the Center of Human Rights at the University of Pretoria, Zimbabwe Exiles Forum, Amandla Mobi. The list is quite strong. And of course, for 13 years, he worked with and the Khulumani Support Group. And I remember he was very active in that regard, which was a social movement of victims and survivors of apartheid as national advocacy coordinator. I remember briefly I assisted the Zebeza team. So the reparations, African Zebeza. So our paths just keep on crossing. That's why you must always keep your friends close. And then between 2021 and 2022, he was appointed chief panelist for the South African Human Rights Commission inquiry into racial discrimination and other forms of discrimination in advertising. He is visiting professor at the International Institute of Social Studies of Erasmus University Rotterdam and faculty member of the Vienna Master of Arts in Applied Human Rights. And of course, he holds a PhD from the University of London, among other qualifications. Ironically, we bumped into each other in a coffee shop when I was attending a conference. Remember? That was just so weird. I'm attending a conference and here he is, he's doing his PhD that side and we bump into each other. So our paths just keep on colliding wherever we go. And of course, he has been designated with some very interesting tasks by the Human Rights Commission, one of them being racial justice, and I think the other was education and others. So let me hand over to Prof Madlingozi, Prof Lings. By the way, he also has a very interesting initiative, also called, that is called the Shabin, don't assume that it's about alcohol. It's about exchange of intellectual ideas, which I think it meets, is it every month or every yeah. So there's no better person and someone who you guys will be able to relate to in terms of this issue. And Prof, the elephant in the room is really for you to unpack this creature that is constitutionalism, the Human Rights Commission, Chapter 9, and all these wonderful things that you are doing. So let me hand over to you, and then we will take it from there. Thank you very much.
Thank you so much, Prof. It's always good to be with you. You forgot to mention one other critical crossing of paths, which is that you are my predecessor at a Chapter 9 institution. We are following on your footsteps. You are the public protector. I'm at the Human Rights Commission. And I must say publicly that the example that you said when you were there, it's a very high standard, and we appreciate that example and that guidance. And we can always tap on you when we face some complexities, because it's a very complex landscape. So thank you so much for the invitation, but most importantly for the work that you did at the public protector and the work that you continue to do even now. I've sent my presentation. I thought it would be, because it's 5 o'clock, people are a bit tired. I thought it would be better to present via a PowerPoint presentation. Can you just confirm, Prof, that you got it? I sent it via email.
I think our team would have received it. I don't know. Let me just check with Karabo, who's managing our. Because I didn't get an email, but I think our team would have gotten it.
Okay. Yeah, please. I've sent it to the email that where you invited me.
Okay. Let me just. Oh, you sent it just now.
Yes.
Okay, let me just check.
But if I can just start so long, thank you so much for this invitation. And
yes, I see the email coming through.
The child is here.
Will you share your screen, or?
I don't know how to do that. I've tried. Screen
right now, yes, I can see the. I can share the screen. I can share the screen from my side. I can share the screen from my side. Just 1 second. You just tell me to stop. Because
perfect, that's the one.
Oh yes. I see Karabo is calling me. Just 1 second.
I've shared the screen.
Yeah, but what you have shared is a correct slide. That's a correct one.
I've shared the screen.
Okay, in the interest of time, I will start. I hope everyone can see the slides. If I can just get a confirmation. I can see it from my side. Is it visible?
Yes, you can go ahead.
Okay. No, thank you so much. Thank you so much.
Thank you very much.
No, just to say that, colleagues, I've been asked to chat a little bit about, thank you so much, Bonolo. Thank you so much, Jacqueline. The role that the Human Rights Commission is playing insofar as social justice and the involvement that law students can have. But of course, as Prof said, this applies to all students. It's not just law students, because the work of the commission is a work that must interest all of us, whether we are law students or not. So what I thought I would do is that I would approach the topic of social justice, which is a very broad topic, from the perspective of my office. So as we can see there on the screen, My office focuses on 3 main areas. I'm a national commissioner responsible for 3 areas: anti-racism, equality, and education. Those are my focal areas. So the commission is a Chapter 9 institution, which means that we are created in terms of the Constitution. And therefore, that means that we've got constitutional protection, because the Constitution is the one that lays out our creation, but it also lays out our protection. It entrenches our existence. As a constitutional body, we are not part of the state. We are also not part of civil society. So we are an independent institution. If you want to put it in a phrase, we are an independent constitutional body. Independent constitutional body. Commissioners, as you know, are appointed by the president. The president appoints commissioners upon recommendation by the parliament. So every 7 years, in our case, it's a human rights commission. When the space is opened in the full board of commissioners, a public announcement will be made. The public will be invited to nominate people that they consider to be people who can protect and promote human rights without fear and favor. After that public nomination, then there's a shortlisting. After the shortlisting is put to the public to say, this is who we've shortlisted as parliament. Do you have any objections, with regard to this name? Tshepo has stolen money, Tshepo is a sexual harasser, whatever. Public can object. We then go for interviews in parliament. It's open process, it's streamed live so that the public can hear, how you are interviewing and the things that you are saying. The CVs are also put in public by parliament so that the public can look at the CVs, can do their own research, and they can object if they want to object. The interviews happened, and then a final list is compiled. And then, of course, after that, there will be background checks by the intelligence services. And then the last step is the appointment by the president. We are appointed for a term of 7 years. 7 years so that we, as commissioners, we can have a guarantee that for 7 years, we can do our work without worrying about reappointment. In the past, it used to be 3 years, 4 years, or in other countries, it's 3 years, 4 years. And of course, what happens is that after a year, a commissioner starts pandering to politicians so that they can be appointed. So 7 years gives you the independence and the guarantee that you won't be bothered for 7 years. The Human Rights Commission has got the broadest mandate of all the Chapter 9 institutions. What are the other Chapter 9 institutions? 1, we've got the Public Protector. 2, we've got the IEC, the Independent Electoral Commission. 3, we have the Commission for the Protection and the Promotion of the Rights of Cultural, Linguistic, and Religious Community, the CRL Commission, and then the CGE Commission. We also have ICASA as one of the bodies. We've got the broadest mandate because our mandate is to promote and protect human rights, which means that it touches on all facets of life. The Public Protector, very, very clear, corruption, maladministration. The IEC, very, very clear scope. The Commission for Gender Equality, very clear scope. Our scope is very, very broad to protect and to promote human rights. And because of that, we've got 7 commissioners. And as commissioners, we've divided ourselves into different focal areas. There's a commissioner who looks at children's rights. There's a commissioner who looks at issues of migration. There's a commissioner who looks at social, economic rights, water, electricity, and so forth. There's a commissioner for climate justice or environmental law. There's a commissioner for land, and so forth and so forth. So my area, as I said, is anti-racism, equality, and education. And of course, these are the areas that I've been working on for the past 20 years. As Professor Malunga was saying, for the past 20 years, this is what I've been working on in civil society and in academia, in that scholar activism focus. From the Constitution, our powers are further elaborated upon by an act, by a piece of legislation called the South African Human Rights Commission Act, which clarifies our appointments, clarifies our functions, our duties, where we start, where we end, clarifies a number of powers that we have. In a nutshell, we have a three-pronged mandate. The mandate to promote, to protect, and to monitor. Promote, protect, and monitor. We promote human rights through seminars such as this, so I'm really thankful for this opportunity, colleagues. So we promote human rights through webinars, seminars, workshops, promotional materials, pamphlets, and so forth, dialogues. The second way the second mandate is the protection mandate. The protection mandate. So the protection mandate is really the mandate to, what does the SHRC stand for? Okay, the SHRC stands for the South African Human Rights Commission. There's someone whose microphone is on, Prof, colleagues. The SHRC stands for...
Yes, we just ask them to please mute, because we're all muted. I don't know. I think it's probably one of the participants.
Yes, yes. So so someone was asking in the chat, what is the sort of SHRC, the South African Human Rights Commission? So I said the first mandate is to promote. The second one is to monitor. That means that as a commissioner and as a member of staff at the Human Rights Commission, I'm allowed to enter any premise with the view of monitoring the observance and implementation of human rights. We monitor sometimes via announced visits. We announce to the person or the institution or an organ of state that we are coming to monitor. But sometimes it's unannounced visits, unannounced monitoring. The monitoring allows us to, on the ground, via inspection, to see how human rights have been implemented at the border, in workplaces, at universities, at all organs of state. We are allowed to enter the place. The last one is the protection mandate. The protection mandate. The protection mandate is where we receive complaints from members of the public. So members of the public are allowed to complain to us, to ask us to investigate an alleged violation of human rights. So we investigate. After investigating, we then issue a report. We investigate and then we issue a report. If we deem the matter to be systemic, meaning it's not just for an individual. If the matter is systemic, let's keep it there. If the matter is systemic, we then conduct an inquiry or a hearing. So normal investigations is an individual, a community, a group of people come to us. But when the matter is systemic and we want to have a systemic intervention, then we will convene a hearing. We will convene a hearing and then give a report with very clear recommendations. The state is not allowed to ignore our recommendations within 90 days. They must be able to give a report. There's so many comments on the side. I'll look at the comments just now. That's why I keep stopping. Apologies for that. So, but please keep asking questions. Within 90 days, the state must not ignore our recommendations, and within 90 days, they must respond to the recommendations. Can we enforce our powers? Just like a court, we can't enforce our powers. A court can also just issue a judgment, but the court itself cannot enforce their powers. Just like the public protector, please let's keep it there, let's not move. Please, let's go there, colleagues. I'll tell you when to move. Just like the public protector, we deem our powers to be binding, meaning that if you don't want to implement our recommendation, you will need to take us to court on review. Some people disagree that our powers are binding, and therefore we are at the moment before the Constitutional Court. A farmer has taken us to the Constitutional Court. A farmer did not want to provide water to a community. We issued a report. They took us to court, and therefore the matter is before the Constitutional Court, where we are arguing that as a Chapter 9 institution, similar to the public protector, our powers are binding. Our powers are binding. In a year, we receive about 6,000 complaints. 6,000 to 7,000 complaints. That's what we receive. We are able to deal with about 5,000 or 6,000 complaints. So that's a lot of complaints that we receive, and we are able to deal with about 6,000 complaints. The majority of the complaints, colleagues, have to do with socio-economic rights. The right to access to water, the right to access to housing, issues of education and healthcare. Those are most of the complaints that we receive, where South Africans are saying, I've got the right to water, but in my community, there's not been water for 6 weeks. For a year, there's not been provision of water or housing, education, as well as healthcare. Those are the majority of the complaints that we deal with. You will never see that in the newspapers, because the newspapers focus on high-profile matters. Apologies, colleagues, but the majority of the complaints that we deal with have to do with those bread and butter issues that South Africans are very much concerned about. The second big categories have to do with discrimination. Discrimination on the basis of race, religion, sexuality, ability, nationality, age, and so forth. So that's the biggest category. So the first big category of those 6,000 complaints, socio-economic rights, so-called service delivery issues. The second big category has to do with equality. So the topic for today is social justice. As I said, there's a number of ways to approach this. I thought I'll approach it by just sharing the work that my office is doing as a basis for our discussion. So as I said, my office, we can go to the next slide, is focused on equality, anti-racism, and education. Let's move to the second slide. We have taken a decision as my office that we will not proactively look at interpersonal discrimination, where somebody has discriminated against someone, someone has called someone the C word, the K word, and other, homophobic slurs or xenophobic slurs. That's very important. But our biggest focus is on institutional racism and structural racism. So Africans are very quick to focus on interpersonal racism. That's very important. But colleagues, if we are serious as a country to move a little bit towards equality, we propose that the biggest focus should be on institutional racism and structural racism. Institutional racism in a sense that after 350 years of colonialism and apartheid, number one. Number two, in the context when 1994, let's be very clear, did not finish the business of colonization. Forget about apartheid. Apartheid was very short. It was about 50 years. What is important is the long history of colonialism. 1994 started the process, but it has not finished. So a lot of institutions that were formed during apartheid and even now, institutionally, are racist. Institutionally, they are sexist, homophobic, ableist, xenophobic, and so forth. That's what we should focus on as a society. How do we tackle institutional racism? Even institutions that have a black face, a black leader, a woman leader, a member of the LGBTQI plus community as a leader, but the institutional culture is still discriminatory. That's the first thing that we need to focus. Structural racism. How a country like South Africa, which is a settler, historically settler colony, where racism was embedded in all facets of life. Racism and discrimination and sexism and patriarchy and ableism have become structuralized. They're a structural issue. They don't even need individuals to do anything because discrimination is in the structure of the system. So the first thing that I want to say is that as a Human Rights Commission, that's where we want to focus on. How do we dismantle institutional and structural racism and discrimination, while also focusing on, of course, interpersonal discrimination, individual discrimination. So that's my first message, colleagues. When we talk about social justice, can we move away from thinking of social justice at an individual level, but to think of social justice from an institutional and structural level? That's the first proposition. The second proposition, colleagues, is that in the context of South Africa, there is no social justice without reparation, redress, and restitution. Let's be very clear about that. Social justice in other contexts, in other parts of Latin America, Scandinavia, is fine. It's about how do you include people in a fair way in society, social justice, a just society. In our context, given our history, social justice is impossible unless we focus very intentionally on issues of reparation, restitution, and redress. We are quite clear about that as a Human Rights Commission. The final proposition, colleagues, on social justice is there is no social justice without social harmony. There is no social justice without social harmony. You can never have a society that is just unless there's harmony in that society, to put it differently. But then we say, what are the conditions that prevent social harmony? The conditions that prevent social harmony is not just lack of social cohesion. We've tried that as a country, social cohesion. Let's just come together. That's important. But it is impossible to create social cohesion unless there is a sense of belonging that everyone feels. And by belonging, we mean two things. Affective belonging, AFFECTIVE, affective belonging. I feel like a South African. Most people don't feel like that because of structural marginalization. They still feel like outcasts in the country of their birth. Affective belongingness. But most importantly, the second part of belongingness, material belongingness. You can only feel that you belong if you share in the socio-economic goods of the country. No social justice without social harmony. No social harmony without affective and material belongingness. And all of that brings us to the fundamental question of the national question. The national question. The fourth proposition that we want to make as a Human Rights Commission is that 30 years into democracy, 30 years since the establishment of the Human Rights Commission, this year, 2025, the Human Rights Commission is celebrating 30 years of our existence. And therefore, we are asking ourselves very difficult questions as a Human Rights Commission. And we are saying to ourselves, our mandate is to promote human rights, not human rights, a culture of human rights. And we are saying that we need, as a Human Rights Commission, to move away from attending to the symptoms of human rights violations, but to go to the root causes of human rights violations. A move from symptoms to the root causes of human rights violations. If we just continue as a Human Rights Commission attending to individual as well as symptoms of, human rights violations, we are not going to move the needle. So we are saying, as part of our critical reflection in the next 10 years, next 20 years, we should proactively look at the root causes of human rights violation. What in South Africa, and I'm putting this to you as a question, what are the root causes of human rights violations? Don't respond by telling me about the symptoms. There's a lack of housing. There's corruption. There's poverty. Poverty is not the cause of human rights violation. What is the cause of, not poverty, impoverishment in South Africa? What is the cause of inequality in South Africa? So you can hear the way we are studying, Prof Madlingozi, that we are interested in very difficult conversations, and that as South Africans, it's high time that we have very difficult conversations. So in my office, we have said that our vision as my office is twofold. The first pillar of our vision is a society where structural discrimination has been dismantled. Not a society where equality has been achieved, or a society where there's no discrimination. A society where structural discrimination has been dismantled. Therefore, we are asking in my office, what are the power relations that make patriarchy possible? What are the power relations that make ableism possible? What are the power relations that make racism, xenophobia, homophobia possible? Not what is the cause of women rights violation, patriarchy. Not what is the cause of discrimination, what is the cause of racism. Not what is the cause of discrimination against members of the LGBTQ community. What is the power relation that produces heteronormativity and structural homophobia? The second part is a society where everyone feels a sense of affective and material belongingness. The first one is about dismantling. The second one is a society where all of us can feel a sense of belongingness, including people who find themselves in South Africa. Let's be clear about that. The Constitution applies like that. We can talk about that. I know it's a popular question. Why do rights apply to people who are not South Africans? We can deal with that. So in terms of our approach, that is a vision. We operationalize this vision through 5 tactics. 1, litigation. 2, inquiries and hearings. 3, training, diversity training. How do we all understand each other? 4, dialogues. And then 5, collaboration with other focal areas in the Commission and with other Chapter 9 institutions. Just before this meeting, I had a meeting with the CRL Commission, where we're dealing with how do we collaborate on the rights of Rastafari people, for example. So we are part of an ecosystem with other Chapter 9 institutions. Therefore, we collaborate. We've collaborated with the public protector, my office, on NEFSAS, corruption within NEFSAS, corruption which is also a violation of the right to education. So that kind of collaboration, so that we don't duplicate, we don't compete as Chapter 9 institutions, becomes very important. So in the remaining time, I don't know how much time I have, colleagues, I'll just go quickly in terms of some of the interventions that we are making so that you can just get a feel of the work that we are doing and how we are proposing, therefore, to shape social justice in the terms that I've been talking about social justice, in the terms that I've been speaking about how, as a Human Rights Commission, with example of my office, how we're doing that. If we go to the next slide, one of the things that we are, the first thing that we're doing is that we have created a diversity manual, a diversity and sensitization manual. This manual says the following. Sometimes when we violate rights of other people, it's because we don't understand those other people, whether it's on the basis of race, culture, religion, ethnicity, sexuality, nationality. It's because of a lack of understanding. So a proactive step that my office has taken as a commission is to come up with a diversity manual which will help people to understand each other. Number one, to train members of the Human Rights Commission. Number two, to propose it to society. That manual focuses on a number of things, including critical diversity. Critical diversity is not the same as diversity. Diversity says just diversify the workplace. But we know that you can diversify the workplace without changing the power relations in that workplace. That's why we can have places that are majority black, but are still racist. Majority women, but they're still sexist. So critical diversity is about attending to the power relations so that diversity doesn't mean assimilation. So that's the first intervention at a proactive level. Social harmony can only happen when there's a mutual understanding. That mutual understanding can only happen when there's critical diversity, when we reflect, all of us, on our unconscious biases, when there's inclusion of visible and invisible disabilities. So that's one example. We can go to the next slide. The next proactive measure that my office, so this is a committee that I appointed to advise me on issues of diversity. So it includes community leaders, it includes social movement leaders, it includes members of faith-based communities, traditional healers, academics and researchers and lawyers. So a committee that advises me on my office and the commission on issues of diversity. This is one way in which you can get involved in the work of the commission as a member of an external advisory committee. This is an example of an advisory committee that is helping us to think about these issues as a commission. Next slide. The second example that I wanted to share with you is the model code of conduct, a model school code of conduct. So, as you've heard, my office also deals with education, anti-racism, equality, and education. We continue to receive a lot of complaints from learners in high schools, in primary schools and high schools about discrimination through the code of conduct, issues of hair, issues of dressing, issues of language, issues of religion. So what we've decided is that instead of just dealing with these issues at the individual level, we will formulate a model code of conduct which will propose to all the schools in South Africa, both private schools and public schools, as a model code of conduct, a comprehensive, constitutionally compliant code of conduct, a constitutionally compliant code of conduct that is applicable not just to learners, it's applicable to the whole school community. So it's not a learner's code of conduct, it's a school code of conduct. It's a constitution of the school, applicable to learners, applicable to teachers, applicable to general staff, applicable to service providers, applicable to parents when they find themselves in schools, applicable to coaches, people like that. A code of conduct that would be a constitution of the school that talks to a number of things. How do we enforce positive discipline? What does restorative justice look like? How do you make sure that you affirm the diversity within the school in a way that doesn't lead to lack of discipline? So that is a second intervention at a systemic level, a model school of conduct, school code of conduct. We have been engaged with a number of stakeholders. Our final consultations will happen in July. We've consulted with the Department of Education. We've consulted with the minister. We've consulted with the South African Council of Educators. The next step is that on the 14th of July, we'll be meeting with the National Association for SGBs. And then we'll also meet with the South African Principal Association, as well as the National Body of Learners, National Body of RCLs. So this will be a code of conduct applicable to all schools that is comprehensive, that is constitutionally compliant. We can go to the next slide. We also have, we've taken a very serious interest in the issues of LGBTQI+. And as a commission, we've not done a lot of work in this area, and therefore we want to proactively do a lot of work in this area. And within that broader categories, the issues of intersex persons become very, very important. So we've been engaging with members of this community, civil society, individuals on how do we promote these rights. Of course, we were involved in the Caster Semenya matter, the athlete, where we intervened at the European Court of Human Rights as a third-party convener. So last year we went to the court to present arguments and to bring to the court the jurisprudence on intersex, so that the athletics bodies can understand and stop discriminating. Is it fine? Okay, yeah.
Please go ahead. I think it's just a technical thing.
Okay, I was muted for a while there. So yeah, so one of the interventions there at a proactive level is a guide for parents of intersex children. Because what happens many times is that when the child is born and the parents sees the child, they don't understand the condition of the child, what is intersex. They are then sometimes forced by some doctors, nurses, to take decisions, drastic decisions about surgery or mutilation of the child that will have long consequences for the child. So the pamphlet is to say to the parents, this is what intersex means. Do take decisions such as surgery, but understand the consequences of doing so. So it's a guide for parents. We're hoping to launch it now in July, Pride Month. We'll be able to launch it beginning of next month. We can move on. So that's one community that we are proactively trying to, assist. We can move to the next slide. I'm almost finished. Next slide, colleagues. The next community that we've been proactively working on, we focus on all communities, as I said, but there are communities that we focus on proactively. One, the LGBTQI community. The other one is the Rastafari community. The Rastafari community. My office view is that this community has been structurally oppressed, structurally marginalized, as well as maybe colonized still in South Africa. Number of issues that present themselves here. Number one, the discrimination of children, of Rastafari children at school when they present with dreadlocks, when they present with certain attires, discriminated against. At the workplace, Rastafari people discriminated against. And of course, the biggest issue is the unlawful arrest. Unlawful arrest. So despite that, there's been a constitutional court judgment, despite the fact that last year, a day before the election, the president signed the Cannabis for Private Purposes Act, which decriminalizes adult private use of cannabis, possession, cultivation of cannabis. Rastafarian people continue to be arrested unlawfully, leading to criminal records. But more than that, leading to a sense of fear because they get profiled, they get searched in public, and so forth. So very, very concerned about the rights of Rastafari community. So we put together a roundtable February this year, after a year of consultation, where we brought together Rastafari people, we brought together the state, we brought together the police, so that how do we find common ground? How do we come up with holistic solution to the rights of these communities? So that's one intervention on the rights of communities, issues of the expungement of criminal records, issues of discrimination in the workplace, discrimination at schools, in the community, issues of, commercialization of the hemp. You will know that the state at the highest level, at the presidency level, very committed to commercialization of insango, matekwan, cannabis, ganja. But that this community still is excluded, they say, from that development because, the cost of getting the licenses and so forth are very, very high. So we have some interventions that we'll be announcing in the next 2 weeks, working together with the CRL Commission. We can move on. We can move on. We can skip. We can skip. The sixth intervention is on equality court cases. So yes, we've got some proactive interventions in the area of, the model school code of conduct, the diversity manual, but we also bite. We also bite, and we bite by strategically taking certain cases to the equality court. So I won't go through those cases, but when we go to the equality court, we normally ask for 4 orders. First of all, if somebody has been found guilty of hate speech, of discrimination, of unfair discrimination and so forth on the basis of gender, religion, sexuality, nationality and so forth, ability, we always ask for 4 measures. 1, a declaration of that the person has indeed violated human rights. It must be on record. 2, in the case of hate speech, we ask for a public apology. You would have seen the public apology by, I'll come to that, but apology. The 3rd one is a fine, where we wanted to hit people in their pocket, so a fine, a monetary fine. The 4th one, a diversity training, as well as community service. You'd have seen the high-profile cases that we've dealt with in the past 2 months. I'm just giving you just recent cases. One concerning Mr. Tshepo Baloyi, Mr. Nota, aka Nota, where he committed hate speech against white people, took him on. He had to publicly apologize, and he's also undertaking some other measures. The second one you'd have seen was Mr. Renaldo Host. Mr. Host, the former member of parliament, who in a video used the K word. Where in a video he used the K word, and therefore we took him on, and he came to us like Mr. Noted Boloy to say, please, let's talk and let's settle. The other one last year was Mr. A councillor, an EFF councillor in Tshwane, where he also, publicly apologized and took other steps. So there's one way, either equality courts, or if we can get all those prayers via mediation, we also do that. So equality court, very, very good vehicle. You don't need a lawyer to go to the equality courts. So we use it to take strategic people to court. So we can skip number 6, so equality court. That's one intervention. You can skip that in the interest of time. The 7th measure out of the 8 measures that I want to talk to is investigations and hearings. Investigations and hearings. And here we are very strategic in terms of the cases that we want to convene hearings on. Not cases, but matters that we want to convene inquiries on. As I said, an inquiry is a mechanism that allows us to undertake a systemic inquiry so that we can have a systemic intervention. 2 weeks where people come and testify, and after that we have a systemic hearing at the policy level, at the institutional level, at the regulations level in terms of our recommendations. I'll just give you some examples from my office. Other commissioners are also conducting some inquiries. One of them that we're going to be issuing a report soon is on the Hartebeespoort Dam. So as you know, the Hartebeespoort Dam, the shoreline is owned by the state. The complaint that came to us was to the effect that 95% of the inhabitants and the businesses on the shoreline continue to be white people. 95% continue to be white people. Black people apply for business licenses. They get rejected, or after being accepted, after a while, their licenses are revoked. But there's also been a lot of fighting, including physical fights around the dam. So we are investigating whether the Department of Water and Sanitation is guilty of racist practices, whether the Department of Water and Sanitation is guilty of not proactively promoting the economic landscape around that area. Some people ask me, can you investigate a state that is majority black for racism? I leave it to you to debate that, but that's one intervention. We'll be releasing the report soon. The second one is on load reduction against ESCOM, against the Department of Electricity and Energy, where the complaint is that load reduction, not load shedding, but load reduction is indirect racism because it applies only to townships, villages, and so forth. That is the allegation. That load reduction is a form of collective punishment, even for people who are paying. So that's an inquiry that I chaired at the beginning of this year, where we had the minister coming to testify, with the group CEO of ESCOM coming to testify, and a lot of communities coming to testify from as far as Limpopo, Free State, about the impact of load reduction. Is ESCOM, the department, guilty of indirect racism with load reduction? So that's also a systemic intervention. And then there's an inquiry that we opened last year into Walter Sisulu University and the police, where last year in April, if I'm not in April or May, I think it was April last year, not this year, where 9 students were shot and those students alleged that they were shot during a protest with live ammunition. So we opened this inquest last year. You have seen what happened at Walter Sisulu this year. So this hearing seeks to find out why did the protests escalate and degenerate. We are asking the SRC, we are asking the students, we're also asking the school management, how do you resolve conflict? Why did this conflict, escalate? Two, we are asking the police from a public order perspective, how do you manage protests that have to do with children? Three, we're asking private security. Do you understand where your powers end? You're not the police. You don't do public order policing. You are there to protect life and to protect, property. But do you understand where your powers start and stop? So that inquiry will be releasing the report coincidentally, and sadly, someone died this year during a protest. So this inquiry of us does not focus on what happened this year, but focuses on what happened last year. The last one, where we'll be issuing a report soon, is on advertising. We received complaints that the advertising sector, number one, is untransformed demographically at the leadership level and at the ownership level, the advertising industry. But two, that the advertising industry is guilty of perpetuating stereotypes and narratives that are discriminatory. What sparked this inquiry, of course, was the Clicks incident. Remember that Clicks, was it Clicks or was it a hair brand, comparing black hair and white hair, for example? But also, so this investigation focuses on advertising, but at a more systemic level, we are asking, what is the role of the media and advertisers in social harmony, in social cohesion, in perpetuating stereotypes and narratives? Why do we have advertisements where a black mother is using her hands to washing, and a white mother is using a machine? So we had this inquiry, and we'll be releasing a report. So this is one of those things that we're doing. The second last intervention, if we go to the next slide, I'm looking at time, my goodness, time is going, is dialogues. We believe in the power of dialogue. So we bite through the equality courts and other judicial mechanisms. We bite like that. Secondly, we bite through inquiries and hearings. But we also believe in dialogues fundamentally, that as South Africans, as people who find ourselves in South Africa, we need to have honest and robust conversations, very robust and difficult conversations. So you'll have heard where I started in terms of unpacking how we understand social justice, issues of colonization, issues of redress and reparation. When I talk like this, some people get offended to say, how can a human rights commissioner talk about issues of reparation and issues of redress and reference in the history of colonization? But we believe that as South Africans, we have, number one, swept a lot of things under the carpet. Number two, we are ahistorical. We lie about history. We are ahistorical. And therefore, our solutions are ahistorical and they are false. So difficult conversations, where we bring people in the room for difficult conversations. This is before the national dialogue story. We've been having this dialogue. So in December last year, we held a dialogue on farms. This is after there were a lot of incidents in Limpopo around farms to do with death, people being killed, to do with people being physically attacked, but to do with a lot of disharmony in farms. So we convened an endeavor that we called social harmony, safety, and nation building around farms in Limpopo, where we had farmers, farm workers, civil society organizations, members of the communities, people who have been victims in the past, and the state. How do we achieve safety? How do we achieve social harmony? How do we achieve nation building around the farm? So that was in December and we produced a report on the issue of racism in schools, very, very concerned as a Human Rights Commission that in 2024, 2025, children as young as 13, 14, 15 are perpetuating racism and discriminating against each other. 14, 13, 14, 15 years old. Intergenerational racism. So very, very concerned about that. So we've opened investigations into a number of schools. We've seen it in the newspapers, but we also believe in dialogue. So we've convened dialogues, and in those dialogues, we get to understand, what is the root cause of racism in schools, public and private schools. Why are young people so young, still infused, not still, but infused with this poison of discrimination? So dialogues are very, very important. And from dialogues, people find one another, and we are able to propose holistic solutions. So dialogues are one key measure. We can move on. One way is via physical dialogues. This was a dialogue in Western Cape that we convened. These children, their testimonies were heartbreaking. Very young children, but testifying about, how they've experienced racism. But what was even more heartbreaking was the solutions that they proposed. These young people, it should not be the burden of these young people, but the solutions that they propose about how their teachers should be taught about history, how their teachers must be, taken to diversity training, and so forth and so forth. Very, very painful. So dialogues would be like this, a round table, very, very difficult dialogues, a safe space. We're not going to use this in court. We're not going to use this in an inquiry, but talk, let's hear each other. So dialogues, some people say dialogues are useless. We don't think so. We believe in the power of dialogues. Let's go on. But the other way, we can go to the next slide. The other way we provoke dialogues is via newspaper articles, because from newspaper articles, we're able to reach a whole number of people where we can have very difficult conversations. So this was a op-ed that we published last year in the Sunday Times newspaper, where we are asking, should we still use racial categories? Black, white, Indian, colored, categories that are non-scientific, categories that are non-biological, categories that were imposed on us during apartheid. It's a provocation. Should we still use those categories? Yes, we must still use them for redress. That's fine. For how long should we still do so? What about people who don't fit in all those categories? But you are forced to tick, even to tick other in certain instances. So this was just a provocation. Of course, from a newspaper, then there are radio interviews, TV interviews, which provoke conversations and dialogues. The last one, colleagues, that I wanted to talk to you about is a 6-year campaign. We can move on. I won't talk to this one. We can move on in the interest of time. The National Question Campaign, that's where I wanted to end, which is that my office has launched a 6-year campaign called the Promoting a Culture of Human Rights and Social Harmony through the resolution of the national question. You can already understand where this campaign is going, is to say that there is no way we can achieve a culture of human rights, of social harmony, unless we've resolved the national question. What is the national question? The national question in the first place is to say, as South Africans, we are not a nation. We are not a nation. Maybe we're a nation when Bafana wins, when rugby wins, then we're a nation, then tomorrow we are no longer a nation. So how do we create a nation? Why does this matter for human rights? It matters for human rights because if we are to build a culture of human rights, we must become a nation. And to become a nation, we must agree on a set of values. But also to become a nation, we must be able to share in the social goods of this country. So this campaign began last year in March last year, 2024, on the national question. Don't confuse it with the national dialogue that is taking place now. That conversation started after the elections. Our campaign started before then, in March, where we appointed another group of experts, not the ones that you've seen, another group of experts to advise us on the issue of the national question. Lawyers, academics, business people, we had social movement leaders, a whole lot of people who are a national question committee that advises. We started in March. The second step was then to say, we want to go around the country asking South Africans, what is the national question for you? And how do we resolve the national question? So we had dialogues throughout the country. But we said we'll focus as a pilot last year, from March last year to now, on TVET colleges. So we focus on TVET colleges because we are quite concerned that normally TVET colleges are excluded in some of these conversations. They feel marginalized. Of course, there are people who are more marginalized, unemployed youth and so forth, but we started with TVET colleges and we went around the country, all 9 provinces, to ask TVET college students, what is the national question? That culminated in the launch. We can go to the next slide. In March this year, where we launched this campaign. It sits in my office for 6 years. We are interested in measures that will help us to resolve the national question. All these things that I've been talking about, we have formulated it through a campaign. You can go to the next slide, where we are asking ourselves this question. So in March, when we launched the campaign, we had the TVET college students from 9 provinces to hear the voice of the youth, from the youth perspective, what is the national question? But we also had 5 panels to reflect and to debate this issue. So for example, the first panel was the Constitution. Is the Constitution still fit for purpose as a framework for the nation? We're not scared to have that conversation as a Human Rights Commission. We're not scared to have that conversation. Can we debate? The Constitution is not a Bible, and therefore we can debate and critique it so that we can improve it. The Constitution itself says, I can be amended. So, very difficult conversation. We had on the panel a number of people, including a prince from the Khoi and San community, who were talking about how they feel excluded from the Constitution. Their language is not one of the 12 languages. The chiefs and kings are not recognized and so forth. With people from the Department of Justice talking about how we can use the Constitution. We had scholars and so the whole of the Constitution. The second panel looked at the political economy. We can't talk about social cohesion, social justice, unless we've looked at the political economy. The budget that the state passes every year, is that budget constitutional? As a Human Rights Commission, we are very concerned that the budget that is passed every year, sometimes is not constitutional in the sense that it does not help us to progressively realize socio-economic rights. The Constitution says socio-economic rights must be progressively realized. Is the budget that we are passing fit for purpose? Are we serious about progressively realizing human rights, socio-economic rights, right to water, electricity, healthcare, and so forth? And therefore, we have appointed a special commissioner to look at pro-human rights budgeting, starting with municipalities, starting with the IDPs of municipalities. Are they pro-poor? When we look at the budget of municipalities, are they evenly spread so that the townships and the historically marginalized places are not left behind? And so forth and so forth. So pro budgeting is very important. We also had sessions on the unfinished business of the Truth and Reconciliation Commission, the unfinished business of the Truth and Reconciliation Commission. That is self-explanatory. But we also have the 2 panels on what is the role of artists. So we had a poet, we had a creative writer. What is the role of, and we had a singer, what is the role of the creative arts in resolving the national question, as well as what is the role of mainstream media and social media in some of these questions? Colleagues, I think I will leave it there, but just to say that I'm just giving you a slice from one office. We've got 8 offices. I'm just giving you a slide of one office in terms of what we're doing to try and to shape social justice. We've got a number of challenges, of course. The first challenge that we have as a Human Rights Commission, as I end, is the budget. Our budget is not enough for the work that we're doing. We've got about 200, just under 200 employees for a country of 60 million. 200 employees for a country of 60 million, 9 provinces. In those 9 provinces, you will have 9 or 10 people. That's not enough. The second challenge is accessibility. So we've got 9 provinces in the headquarters. You go to a province like Eastern Cape with 1 provincial office, it's not enough in terms of accessibility. So we have a lot of outreach activities. Last year, about 650 outreach activities. So we try, but it's still not enough. We are unable to access most people. So we are trying to, how do we leverage technology? Can we have mobile clinics and so forth? So accessibility is a problem. The third challenge that we have, colleagues, is the fact that some you can leave it there. The third challenge that we have is that some municipalities are dysfunctional. Some municipalities are dysfunctional. So I will go to a municipality, come out with a very good deal. When I go after 2 months, there's a new municipal manager. There's a new mayor. Dysfunctionality. Or some municipalities and state departments, lack of capacity. So not that people want to be corrupt or that they don't want to implement our recommendations. Capacity. Have you appointed the right people for the right job? So capacity, dysfunctionality, very, very big concern that we should all be concerned about. You know, and then lastly, political will. As South Africans, we should debate political will. Do we have the political will to promote a culture of human rights as individuals, as the state, as big business, as civil society? Do we really have the political will to have a commitment to a culture of human rights? Not just your culture as an individual, not just your culture as a family, not just this idea that I will privatize my life, I will have my own healthcare, my own security, my own electricity, I will privatize my life. That's not a commitment to a culture of human rights. As individuals, do we have the political will to embrace human rights? As a state, do we have the political will as a state to promote a culture of human rights? I'll just leave it at that. Thank you so much, colleagues.
Thank you so much, Prof, for the great journey. I think I've always said to both our faculty members and of course the students at Genesis Law School, and of course and many of these participants in these masterclasses, that our law is a tool for justice. It's a thinking tool. It gives us a chance to interrogate, what rights people have, etc. And that the Constitution, I can't seem to find my little book there. That's a living document. It walks, it talks, it addresses the challenges that people have in society. And I think Prof Madlingozi has done a very fantastic job of doing that. So I think there's some comments there. If we can scroll through them, Prof, and then you can respond to them.
Well, thank you so much. Some of them are comments. They are some questions on load reduction. That load reduction.
Yes. So we can maybe I don't know if you can see the screen.
I can see some of the comments, Prof.
Yes. Should I go through them or you go through them yourself?
I don't know how you want to do it. But
okay. Maybe for speed, I'll just read and you respond. There's the first one. Ben Dalo says, "Do we have ethics and empathy for the public we are serving, and do we have ethics as the public?" I don't know whether she's referring to you as the Human Rights Commission or.
Should I deal with them one by one, or how do you want to do it, Prof?
Yes, I think one by one.
Okay.
Some of them are similar, one by one.
Yes. No, that's a very good question. It goes to what I said later on for all of us to ask ourselves whether do we have a political will as human beings? Do we still have the spirit of Ubuntu? For us as public representatives and also as public appointees, we are supposed to adhere to the principle of batupili. But we violate that a lot of times. So it's a good question. How do we make sure that we embrace in reality the spirit of batupili? But as I said, colleagues, it's all of us. We can blame leaders, we can blame the state, but do we take our civic duties seriously in terms of civic? Do we understand our rights? Do we understand the Constitution? Or do we use the Constitution selfishly to apply only to us, but not to some people? That's not how the Constitution works. That's not how universal human rights work. So the question of ethics is very, very important. And it goes to my last question that all of us need to embrace the spirit of Ubuntu, the spirit of Batupili, not as a slogan, but as a fact. Thank you.
Yes. Thanks, Prof. The one that's from Bongani there is one I decided to go for it because in the interest of time, it's something that comes up very often.
Which one? The one about
enforcement. Yes, I don't know what happened to it. He says one of the problems is that you lack. Yes, I maintain that part of the problem is that you have no power to enforce. I remember that when I was a public protector, we even had to go to court about this.
Yeah.
So I don't know if you have a response to that.
Yeah, no, as I said at the beginning, colleagues, we are before the Constitutional Court now, where we are fighting for the declaration that the powers of the Human Rights Commission are binding, that our powers are binding. So you'll recall that the public protector, as Prof was saying, had to go to court, the EFF, the Nkandla case, where the Constitutional Court affirmed that indeed the public protector's powers are binding. We maintain three things. One, Chapter 9 does not create a hierarchy of Chapter 9s. The fact that the public protector is mentioned first doesn't mean it's more powerful.
Yes.
The drafters of the Constitution intended Chapter 9 bodies to be the same. So there's no hierarchy.
Absolutely.
Number one. Number two, that the phrasing is different, but the phrasing is the same. Take remedial action with the public protector, for the Human Rights Commission, take measures to redress. It's the same thing. It's the same thing. Same phrasing, different phrasing, but it's the same thing. But number three, we maintain that to expect the Human Rights Commission in all 6,000 complaints to go to court to enforce our powers, that's impossible. 6,000 cases to go to court to enforce our powers in 6,000 complaints. We don't have the money, we don't have the time, and certainly to expect members of the public who are coming to us on issues of water, electricity, to wait for 4 years for a court to make a decision. That's not what the drafters intended. So it is part of the power, it is part of the issues that we can't enforce our recommendations, but we're before court. That's number one. Number two, even the public protector can't enforce their powers. Their powers are binding, but they can't enforce their powers. The courts can't enforce their powers. The courts give a judgment, which is binding, we know, but the court cannot physically take a municipality to build a house or so forth. So we have a very big issue, Prof, on the issue of political will. So even if our powers can be declared binding tomorrow, just like the public protector, or even the constitutional court, we've got a difficulty that some municipalities and some individuals simply don't enforce court orders, don't enforce the recommendations of the public protector, the Human Rights Commission, and so on. So that's why in our court case before the Constitutional Court, the CGE has come in as an amicus. The civil society organizations have also come in as amicus. So I ended up this intervention today, colleagues, by this issue of political will. It's a huge issue, and we should all be serious, and we should really put pressure on politicians, big business, and individuals to respect constitutional bodies. So that's one thing that we're doing. The other thing that we're doing, of course, is to make use of our subpoena powers. So in terms of our act, we are allowed to subpoena anyone on any issue. So that's not a hearing, that's not a court case, it's a subpoena. I'll just give you an example of 2 subpoenas that I checked this year. One subpoena had to do with a Mfuleni municipality. We know the issues there, and therefore we subpoenaed the municipal manager to say, we've been writing to you, you have ignored us, we've said let's meet, you have ignored us, now we are subpoenaing you. And of course, in subpoena hearing, as a chair of the hearing, I swear in the person, I administer an oath. So you can't lie in an oath. Secondly, the subpoena is public, so the public can follow. So it's a very important tool to hold officials accountable through a subpoena. They make commitments, those commitments are on record, and we are able to follow those proceedings.
Okay. Very fascinating. There's one from Nompumelelo. She says, what is the South African Human Rights Commission stance on demands made by refugees in Cape Town who demand to be relocated to Canada by the South African government? I don't know this one. I obviously know the very famous one of the Trump one. I don't know if you can.
Yeah, no, I saw it in the newspapers. I think it was beginning of this year. Yes. But I've not followed that. I will follow up with the commissioner responsible for migration, but certainly
migration, yes.
The state has money to relocate people to Canada. I will be very surprised if under international law there's an obligation on the state to relocate refugees to a different country. Refugee comes to your country because they're fleeing persecution. They come to your country because they're fleeing persecution.
Yes.
There's an obligation that we call a non-refoulement.
Yes, the non-refoulement, yes.
Obligation. You can't send the person back to that country or to a third country willy-nilly. That's an obligation. But there is no obligation to then transmit those people to another country. No. I'll be very surprised. Let me not say anything because I don't deal with migration.
Great. Yes, these guys have done international law. So some of them have done international law. At least they have an idea on. And then a quick one from Zulu Baloy. He says, can one get cases on the system or your portal? I suspect in terms of your findings.
I didn't get that.
Can one get cases on the system or your portal?
Which cases? The one that I've been.
I suspect that she's talking about the findings of the South African Human Rights Commission.
Yes. Our website needs to be updated. It's a very big concern. We do a lot of good work, but we were in the process of brand management. Some of the things that I was saying now are new to some of you, because we don't. So we are refreshing our what is it called? Our website, so you can get them on the website, but you can also write to me. Prof has got my details. I get paid by you, so please don't hesitate to write to me, and we can take it from there.
And then Sean is a bit controversial and interesting. One, he says Afrikaans language in primary schools and high schools for African people. Why is it still relevant? And
Yes,
says,
we as the South African Human Rights Commission strongly supported the Bella Bill, the Basic Education Laws Amendment Bill. We strongly supported that bill. Then the bill was signed but was not enforced. We wrote to the president and we published that to say, President, why are you not signing this act? We understand that the conversation within, a cabinet. What is the role of the Human Rights Commission? Also, legislatively, what is this process? So I'm saying this because to say that we took a very strong stance on the Bella Bill. The Bella Bill or the Bella Act regulates issues of language. And you will see from now on that the question that you are asking will be dealt with through Bella to say, what is a fair situation when the majority of learners are of a certain language? What language should be there? What language should
Recording
be
stopped.
the majority? So I'm saying, if there's a specific case, please bring it to us. But at a global level, I would say that the Bella Bill will really address that.
Thanks a lot. And then he says, why allow communities such as Kleinfontein and Pretoria and Orania to exist in a democratic constituency in South Africa? And then he also says, why is the Human Rights Commission not available in townships such as Soweto, Umlazi, and Khayelitsha?
Yeah, the second one I've dealt with, please ask the state to give us more money. Please ask the state to give us more money. For the past 3 years, our budget has been cut in real terms. I will say that publicly. Our budget has been cut in real terms, and we do our best. But if we have more money, we are able to have satellite offices. We're able to have mobile offices.
And outreaches, yes.
And through media, right now you can go to our website to submit a complaint. You can go to social media to submit your complaint. We have also moved to a situation where all the provincial offices have got WhatsApps. So you can submit a complaint or an inquiry via WhatsApp as a way to, to submit your complaint. The next step is that we are in the process of developing an app which will make it easy for people to be in contact with us. So that's some of the ways that we are doing to leverage technology. The Orania and Kleinfontein, I won't say much, but watch this space.
Okay. And Mr. Dennis Juru, he wants to say something. He's got his hand up. So I think the technical team will unmute him.
Yes, am I audible?
Yes, you are.
Thank you. How are you, Prof?
I'm good. How are you?
I'm good. My name is Dennis Juru. I'm a third-year student at Regenesis Law School, and I'm also a student representative. So thank you for sacrificing your precious time, especially after work hours like this. We really appreciate that, Prof. We also appreciate your clarity on a number of things. That includes the issue of Rastaman. I know that we always view Rastas as darker people, but it's not the real truth about them. Thank you about that clarity. Prof, I don't know whether it's a coincidence or what with Advocate Malunga, because last week we were writing international law and Israel attacked Iran. And this time around, you also touched about the intellectual property, yet we also wrote international property some few days ago. My first question, I think someone asked it and you responded to it just now, which was about if you have power to enforce, because some may view the commission as, sorry to say this, it's unprofessional, but that's how people, not myself, view the commission. Some, they may say your commission is like a toothless bulldog, no matter how much it bites, you know that it will never bite me. Even if it tries to bite me, I won't feel any pain. But at least you did give clarity on that one. I have an issue which I will set as an example here. As you know, there's this issue of building hijacking, especially in Gauteng. Building hijacking.
Hijacking of buildings.
Yeah.
Yes. I have someone I know who had a complex, and only last month there were some thugs who came and removed all his tenants and put their own tenants, and they started receiving rentals from those tenants. We all know that Section 25, subsection 1 of the Constitution of South Africa talks about property, that no one may be deprived of property in terms of law. No one can be deprived of property without reading the whole section. We also have Section 26, which says everyone has the right to have access to adequate housing. How do you balance the two as the Human Rights Commission? Because you need to defend the previous occupiers who were removed by the illegal occupiers, and you also need to cover the new tenants using Section 26, which talks about the right to have access to adequate housing. The other question is, I heard you saying you receive plus or minus 6,000, from 6,000 to 7,000 cases. So I can say you preside over those cases annually. What is your rate of success in those cases? Of the 6,000 cases, how many do you resolve as a conflict resolution way or by using courts? Because you know that even if you win in court, some they might backfire and go to a higher court. And then lastly, how do you push the adjudication of cases so that the case may not be overtaken by events? Like, for example, what I said recently, to say there were some building hijackers who took over the building, and then you go to court. Since you said you don't have the power to execute, you report the case to the courts, and the courts, with the backlog they have, they might take even 4 years. And now those people who were evicted are now relocated. Some, they even bought their houses. How do you fight for the cases to be given first priority in order not to be overtaken by events. Thank you so much. Sorry for taking this much time.
Advo, can I go? Or?
Yeah, please go ahead. Please go ahead.
No, thank you so much for those questions. Please don't apologize. We are here to exchange, and I'm also here to learn from you. No, we're not toothless. Please try us. You'll see what happens. No, we're not toothless. As I said, there are people that have had to pay 100,000, 150,000 for, for violating, the Equality Act or other legislation. So we take people on. I'm just giving you some high-profile cases where there's been clear consequences. There's been very clear consequences, certainly. The inquiries that we've had, as I said, the ministers come and testify and really, take hard-hitting questions, and we have had successes. I'll just give you an example of the July 2021 unrest. The July 2021 unrest, we held an inquiry in 2022, and we issued a report last year. And we made recommendation in respect of about 9 state departments and some 2 private entities, including CIRA, the regulator of the self-regulator of private security. And last year, by after 90 days, some of them had not come back to us. We issued a public statement to say, we are going to take you to court, and as we stand now, 8 out of the 9 departments, Presidency, Department of Justice, Intelligence, and so forth, have really given us comprehensive reports on how they're implementing our recommendations, because they understand that we're not toothless, and that we can take them on via the courts, via Parliament, and other measures. So we do that, but it's not just the Human Rights Commission, it's also the courts. I repeat myself, where courts give judgment and sometimes people don't adhere to those judgments. Are the courts toothless? Would you say the courts are toothless then? We have a problem of political will in South Africa, and it's a culture of impunity that came from apartheid, and there are some continuities. A culture of impunity where people don't want to be accountable. At home, as individuals, in society, as individuals, someone was talking about the noise pollutions in the townships. People not adhering to bylaws, just blasting, the noise. And noise pollution violates psychosocial rights of people. People are not able to sleep. Kids grow up with anxiety. Some of us who grew up in the township, some of the things that we do don't make sense, but because we grew up with this noise that we have now, sort of learned to valorize as classic culture, as ghetto vibe. No, it's not ghetto vibe. It's abnormal. It's abnormal, and so I'm saying, as a society, we've got big problems. But as a Human Rights Commission, we are able to subpoena. We've got the powers to search and seizure as the Commission. We've got the powers to go to court. We've got the powers to conduct inquiries. We've got the powers to do so many things. So, no, we're not toothless. We do act, but we need more money. We need political will. All of us need to work together. Success, I don't have the figures in front of me. We're going to be releasing an audit of the implementation of our recommendations, just as a global audit, to say, out of the 10 inquiries that we held in the past 5 years, there's been a 60% compliance rate with our recommendations. So we will release that. We have set up a monitoring unit to monitor the rate of compliance with our things. We've had a lot of successes, even at the policy level, in influencing policy reforms, at the level of policy reforms. Hate speech now, they say hate crimes, where hate speech is a crime. that's part of the work that we have been doing as a Human Rights Commission through, a lot of work that we've been doing on hate speech. Now it's the time, so legislation, influence, someone was talking about the taverns again, the Inyobeni. We had an inquiry, with Inyobeni Tavern, where we are looking at Inyobeni Tavern, but we're looking at systematic interventions on the issue of taverns. It's a human rights violation that some taverns do not respect bylaws and are within residential areas. They are within a few, meters from schools, education facilities, and we had very clear recommendations. Those recommendations the state has implemented. Scholar transport with inquiries in the Eastern Cape. We are seeing movements in the Eastern Cape on issues of scholar transport. I can go on and on. So there are some successes. There are also setbacks. There are also setbacks that require us to change our strategy, change tax, collaborate better with other Chapter 9 institutions in the ecosystem. But I'll be lying to you if I said that we have achieved a lot of success as a society because of this culture of impunity. We have a long way to go, but as a South African Human Rights Commission, we commit to continue to working hard and to always pushing. Hijacking of buildings, it's a violation of the right to property of property owners. Let's be very clear about that. Some of the hijacked buildings is because owners have absconded. Some of the buildings because the owner moved to London and died. But sometimes they're hijacked because, of criminality, criminal syndicates. We know in Johannesburg that criminal syndicates organize crime on issues of hijacked buildings because they know that the issue of shelter, it's a huge problem in Johannesburg because it's a place that pulls a lot of people because of job opportunities and educational opportunities. People move to Joburg, so there's an issue of lack of space and lack of shelter, and therefore the criminal syndicates that are involved in this. We've had a lot of discussions with the city. The city has got a very good policy called the bad buildings policy. We support that policy. We continue to call for the state to exercise their powers to expropriate, those buildings, bad buildings causing harm, causing, an eyesore, but also violating bylaws, violating the rights of the people that live there. People sharing, 10 families sharing one toilet because it was in office buildings. It was not meant to be a residential building. So we continue to say to the state, you must exercise your powers to expropriate. We are at present before the Usindiso inquiry, where we are making these arguments. So the issue of hijacked buildings is a very sad issue because you're quite right. As you expropriate the people who are rendered homeless, what do you do with those people? Is your position to say those people knew what they were doing and they must be cast out in winter? Our laws and our jurisprudence say that there must be alternative accommodation, that as a country we've decided that homelessness must not be something that is, that the state caused. The state must not cause, homelessness. The state must, as far as it can, offer alternative accommodation. So it is a very tricky balance. But I'm saying that number one, we must really dismantle this organized crime, not just committed by foreigners and non-nationals. By the way, South Africans are also part of this organized criminal syndicates that hijack buildings. The state must expropriate bad buildings. The state must have a clear policy of urban social housing, inner city social housing. The state has got some policy on RDPs, upgrading of shared settlements, but inner city social housing, we should really, commit ourselves to that. And then lastly, spatial justice. South Africa continues to, we have not done enough as a country to realize spatial decolonization. Decolonization, we have not done that. We've accepted that townships must still exist, even though townships were created as not places for human beings to live, but as a camp for labor. But we've accepted that townships must live. What is the place of townships, settlements in post-apartheid? It's a philosophical question. I'm not asking you to answer that now, but spatial justice. 6 o'clock where I live, I see a lot of people lining up to go to home. They work in the suburbs, and then they have to be chucked out, to go back to the townships. And people spend 40%, 50% of their salaries on transport. It's unsustainable. But yeah, we need to strike that balance between the rights of property.
While you're on that one, there's a very interesting question after what you've just said. A question from Tshepo. Maybe let's just take 2 more questions and we'll call it a wrap because we're reaching the time. It's a fascinating one. Tshepo Modimola says there's a serious noise problem in the townships, which in my view is a serious violation of human rights and badly affects quality of life, e.g. taverns, clubs, and general inconsideration, that is noise pollution. So I don't know how you can handle that one. If you
I thought I did, Prof. I thought I did when I was talking about the fact that it is a human rights violation. It violates bylaws. Those bylaws exist precisely to ensure that we are able to coexist, And this idea in the townships, it must be a vibrant, noisy place. No, that's not fair. That's not fair. People are unable to sleep. Kids grow up with anxiety because of noises, of people fighting, coming back from the taverns. The taverns must exist, the shepherds must exist, but they must respect bylaws, they must respect zoning laws, they must respect noise pollution laws. It really takes away from the quality of life. People are unable to sleep, leading to other conditions, psychosocial conditions.
And I remember those children who died in the Eastern Cape.
Yes, I also mentioned that the issue of Inyobeni, I've also mentioned what we deal with that, yeah.
Yes. And then I think there's Philip who says our problem is that they're still holding development in the laws are our courts. So I think he's saying maybe if I'm getting his comment correctly, is that the courts must unlock the powers of the Human Rights Commission. Is that what he's saying? I don't know.
Yes, let's make that our prayer. The courts.
Okay. Yeah, there are some other comments, but I think we are sort of like out of time. And then of course the slides, with your permission, we can share them to those who want to.
It's a public entity. The work must not be privatized.
Yes. So Ntabi says the slide is going to be made available, and your email is there as well for those who want to lodge complaints, etc. I just want to check: is there any lecturer who wants to say anything? But other than that, we really have had a very fascinating conversation, and I just want to thank Prof Madlingozi for the insightful conversation. And those who are studying law, obviously you can see now that there's no one size fits all when it comes to the career. When you finish your LLB, the Human Rights Commission may very well become your employer. Or you can get involved in this kind of litigation in your practice as an attorney or advocate. It is possible. It's not everyone who wants to sit and sign contracts and so this is the constitution at work as far as I'm concerned. And I just want to thank Prof Madlingozi. I don't know, Prof, if you have any closing remarks for the participants.
No, thank you so much. Thank you so much. Someone said, I think it was Joe said, thank you for spending your time after hours, but I should also thank you. it's the end of the month. I know some of you.
You saved them their monies. You've saved them because most of
Yes,
these guys are
yes.
working. They've been paid in one way or the other.
Yes. So just to thank you for sacrificing your evening for this unsexy discussion, and we've got a lot of work to do. As Jacqueline was saying, there's a lot of work to do, but with your support,
Yes.
continue
Thanks,
to critique us. You must critique us. You must criticize us. We are a public entity. We should not be defensive. But other than that, let's work together, please. Thank you so much, colleagues.
Thank you so much. And thanks to everyone for your time, and have a lovely weekend and a great week. Thanks a lot.